Question number 201. Which of the following is not an essential condition for the application of rule of lis pendens under section 52 of TPA? Options are pendency of a suit or proceeding, pendency in a competent court, suit must be collusive, alienation must affect the right of other party. Correct answer is option C, that is suit must be collusive is not an essential condition. Question number 202. The rule of lis pendens embodied in section 52 of the TPA pertains to bona fide purchase, public policy, auction sale, none of the above. Correct answer is option B, that is public policy. Question number 203. The doctrine of lis pendens is explained in famous case of, correct answer is Bellamy versus Sabine. This is the leading case in which the lis pendens has been explained. Question number 204. The object of lis pendens is to only maintaining the status quo, only restraining further litigation, only restraining creation of a new fact during the legislation, all of these. Here correct answer is all of these. Question number 205. The rule of lis pendens applies when the suit in which right to immovable property is fraudulent and is directly in question, is pending between two persons and one of them sells property, is pending in a court which does not have jurisdiction. Correct answer is option C, that is pending between two persons and one of them sells property. Question number 206. For applicability of doctrine of lis pendens, the property must be movable, immovable, both A and B, none of these. Correct answer is option B, that is immovable. Question number 207. During the pendency of a suit for recovery of an immovable property, if the defendant transfers the property, the decree can be executed against the transferee. The decree cannot be executed against the transferee. The plaintiff should file a fresh suit against the transferee. The plaintiff has no remedy. Correct answer is option A, that is the decree can be executed against the transferee. Question number 208. The doctrine of lis pendens applies where suit is collusive, where the transfer is made during the pendency of suit, where the title to movable property is an issue, where the property is situated beyond the territorial jurisdiction of the court. Correct answer is option B, where the transfer is made during the pendency of suit. Question number 209. Doctrine of lis pendens embodied in section 52 of TPA invalidate the transfer of immovable property during pending of the suit. It only enacts that the purchaser pendent light suit is bound by the result of litigation. It barred the transfer of property during pending of the suit. It protects the right of collusive transferee. Correct answer is option B, that is it only enacts the purchaser pendent light suit is bound by the result of the litigation. Question number 210. The doctrine of lis pendens is applicable during the pendency of the suit, after filing the suit, after disposal of the suit, before filing of the suit. Correct answer is option A, that is during the pendency of the proceeding. Question number 211. The doctrine of lis pendens would apply against the defendant who has transferred the immovable property from the date of filing of the plaint, service of notice, appearance before the court, hearing of the court. Correct answer is option A, that is filing of plaint. Question number 212. Transfer of property pending suit thereto, the transferor shall be void, affected by the decree or order of the court, illegal, infructuous. Correct answer is option B, that is affected by the decree or order of the court. Question number 213. The doctrine of lis pendens applies where the suit is collusive, the transfer is made after the decree of the trial court but before the filing of an appeal, right to movable property is in question, property is situated outside the territorial jurisdiction of the court. Correct answer is option B, the transfer is made after the decree of the trial court but before filing of an appeal. Question number 214. Lis pendens is not applicable to suit proceedings which is, options are ex parte, collusive, pending service of notice, in execution. Correct answer is option B, collusive. Question number 215. Which one of the following condition is not an essential condition for application of rule of lis pendens under section 52 of TPA? Options are pendency of a suit or proceeding, pendency in a competent court, suit must be collusive, alienation must affect the rights of the other party. Correct answer is option C, suit must be collusive is not an essential condition for the application of rule of lis pendens under section 52. Question number 216. A settlement made to defeat and defraud creditors is voidable in which section of TPA? Options are section 52, 53, 54, 55. Correct answer is option B, that is section 53. Question number 217. Under which section of TPA fraudulent transfer is defined? Options are section 21, section 35, section 53, section 41. Correct answer is section 53. Question number 218. Which section of TPA bars fraudulent transfers? Options are section 43, section 53, section 63, section 71. Correct answer is option B, that is section 53. Question number 219. Which of the following case decided by the Privy Council relates to fraudulent transfer? Correct case is Mushahar Sahu versus Hakim Lal. This is the right answer. Question number 220. Every transfer of immovable property made with intent to defeat the creditors of the transferor is voidable at the option of any creditor so defeated, void ab initio, voidable at the option of the transferee, none of the above. Here correct answer is option A, that is voidable at the option of any creditor so defeated. Question number 221. Part performance of a contract for sale of immovable property is contemplated under which section of TPA? Options are section 51, section 52, section 53, section 53A. Correct answer is section 53A. Question number 222. The doctrine of part performance cannot defeat the right of a transferee for value, gratuitous transferee for value if he has notice of the contract, or his part performance, transferee for value and without notice of the previous contract of its part performance. Correct answer is option D, transferee for value and without notice of the previous contract of its part performance. Question number 223. What act does not constitute part performance? Options are delivery of possession, act done in performance of the contract, and unequivocal act which is referable to no other contract than alleged, acts introductory to and previous agreement. Here the correct answer is option D, that is act introductory to and previous to the agreement. Question number 224. Prabodh Kumar Das versus Dantmara Tea Company Limited case is related to which of the following doctrine? Options are A, doctrine of election, B, doctrine of list pendants, C, doctrine of part performance, D, doctrine of priority. Correct answer is option C, that is doctrine of part performance. Question number 225. Which is not the ingredient of section 53A of TPA? Options are agreement for transfer, consideration, transferee has performed his part, movable property. Here correct answer is movable property. Question number 226. The case of Arif versus Jadunath is related to which of the following? Apportionment, fraudulent transfer, part performance, none of these. Here correct answer is option C, that is part performance. Question number 227. Provision of section 53 of Transfer Property Act. The rights of the following transferee for consideration shall not be affected. Options are who is a gratuitous transferee, who has notice of the contract, who has no notice of the contract, whether he has notice of the contract or no notice of the contract. Correct answer is option C, who has no notice of the contract. Question number 228. Which of the following is a leading case on the doctrine of part performance? Correct answer is option C. Mohammad Musa versus Ashok Kumar Ganguly is the leading case on the doctrine of part performance. Question number 229. To apply the doctrine of part performance laid down in section 53 of TPA, the transferee must be always ready and willing to discharge his part of obligation under the contract. The contract must be in writing and signed by the transferor, and the terms and conditions must be certain. The contract must be for value, not gratuitous. Option D, all of the above. Here correct answer is option D, that is all of the above. Question number 230. Which one of the following cases does not pertain to the doctrine of part performance? Options are Arif versus Jadunath, Prabodh Kumar versus Dantmara Tea Company, Sardar Govind Rao Mahdik versus Devi Sahai, Ram Baram Prasad versus Ram Mohit Hazara. Here correct answer is option D. This case is not related to doctrine of part performance. Other three cases are related to doctrine of part performance. Question number 231. No right of action is conferred on a transfer in possession under an unregistered contract of sale. Which section of TPA contains these principles? Options are section 35, section 41, section 53, section 53A. Correct answer is section 53A. Question number 232. For part performance of the contract, which is not an essential ingredient? Options are contract to transfer immovable property, contract is in writing and signed by the transferor on his behalf, transferee is in possession of the property, transferee has paid full consideration. Option D, transferee has paid full consideration, is not an essential ingredient for the part performance of contract. Question number 233. Which one is not essential for the doctrine of part performance? Options are contract is for consideration, contract must be for movable property, must be in writing and signed by transferor, the transferee must have received the possession of the property. Here correct answer is option B. Contract must be for movable property is not the essential for the doctrine of part performance. Question number 234. Cooper versus Cooper 1874 relates to rules against property, doctrine of election, doctrine of part performance, transfer for unborn child. Here correct answer is option C, that is doctrine of part performance. Question number 235. Transferee of the part performance has right to protect his possession. Options are wrong. Right can accrue only after the payment of full consideration. Option C, right. Option D, delivery of possession is not necessary. Here correct answer is option C, that is right. Question number 236. The doctrine of part performance under the Transfer Property Act does not apply to. Options are oral contract, standing timber, is subject matter is grass, D, all of the above. Correct answer is option D, all of the above. In these all, the doctrine of part performance doesn't apply. Question number 237. Under TPA, which one of the following is not correctly matched? Options are transfer by ostensible owner, section 41, doctrine of part performance, section 53B, fraudulent transfer, section 53, doctrine of list pendants, section 52. Here it has been asked which of the following is not correctly matched. Option B, doctrine of part performance, section 53B is not correctly matched. Question number 238. An easement is extinguished only when either the dominant or the servient heritage is completely destroyed. Option B, only when the same person becomes entitled to the absolute ownership of the whole of the dominant and servant heritage. Option C, both A and B. And option D, neither A or B. Correct answer is option C, that is both A and B. Question number 239. Match list 1 and list 2 and select the correct answer by using the codes given below. List 1, condition restraining alienation, is provided in section 10. Agreement to sell, right in personam, and sale, right in rem. Fraudulent transfer provided in section 53. By going through these matches, the correct code will be option C. Question number 240. List 1 and list 2. Condition restraining alienation, this we have already discussed, section 10. Contingent interest, section 21. Part performance, section 53A. Rule against perpetuity, section 14. By going through these matches, the correct code here will be option A. Question number 241 is also again match list 1 and list 2. Here Mushahar Sahu versus Lal Hakim Lal is fraudulent transfer. Madison versus Elderson is related to part performance. And Ram Kumar versus McQueen is related to transfer by ostensible owner. And MST Dhanpati versus Devi Prasad is related to doctrine of election. By going through these matches, the correct option will be option B. The definition of sale is contained in the Transfer Property Act 1882 in section 54. Question number 243. Dash is a transfer of ownership in exchange for a price paid or promised or part paid and part promised. Correct answer is option A, that is sale. Sale is a transfer of ownership in exchange for a price paid or promised or part paid and part promised. Question number 244. Section 54 of TPA deals with. Correct answer is option A, that is sale. Question number 245. Under TPA, sale is a transfer of an interest in a specific immovable property, a right to enjoy immovable property, ownership, none of the above. Here correct answer is option C, that is ownership. Sale is a transfer of ownership. Question number 246. According to section 54 of TPA, a contract for sale of immovable property, create any interest in the property, create charge on the property, confer title on the property, a contract that a sale of such property shall take place on terms settled between the parties. Correct answer is option D, that is a contract of sale of such property shall take place on terms settled between the parties. Question number 247. Tangible immovable property of value of this amount or upward can be transferred only by a registered instrument. Here correct answer is option A, that is rupees 100. Question number 248. Sale under section 54 of TPA is a transfer of ownership in exchange for price paid, price promised, price partly paid and partly promised. All of the above are correct. Question number 249. Which one of the following is not an essential element of sale? Options are parties, subject matter, transfer of convenience, payment of price in cash. Here payment of price in cash is not an essential element of sale. Question number 250. Transfer of tangible immovable property of the value of rupees 100 can be made only by a registered instrument, by an unregistered instrument, by delivery of property, by placing the buyer in the possession of the property. Here option D is the right answer, that is by placing the buyer in the possession of the property.